Good morning. My name is David Bobb. I serve as director of the Allan P. Kirby Jr. Center for Constitutional Studies and Citizenship at Hillsdale College. We're here in Washington, D.C. Hillsdale College, as many of you know, was founded in the 19th century, in 1844, but we're here today very much in this 21st century spot. Before Hillsdale College arrives at our building, we've been holding lectures, and in particular, this lecture series at various places around the city. This morning, we're delighted to bring to you a topic of very timely significance: a supreme standard, constitutionalism, and the Supreme Court selection process. Is a topic very ably addressed by today's speaker, whom you'll hear about more in just a moment. Ed Whelan has been doing wonderful work, for those of you who don't know his blog, at Bench Memos, and you should check that out online. A lot of coverage about not just the current nomination contest and deliberation, but about a whole range of judicial, legal, and indeed constitutional issues of utmost importance. This is a regular lecture series. The First Principles on First Friday's lecture series will live up to its name on the First Principles side in July, but not on the First Friday, because it conflicts with the Independence Day celebration. So on July 9th, Friday, July 9th, we'll have our next lecture. That program will feature David Horowitz, and he's going to speak on the topic, Rules for Radicals, What Constitutional Conservatives Should Know About Saul Alinsky. So you won't want to miss that. That's the same time, 7:30 a.m. on Friday, July 9th. You'll find out more information via email from the Kirby Center, or you can go to our website at thekirbycenter.org. Introducing our speaker this morning is Hillsdale College student and Kirby Center intern Amy Benjamin. Amy is majoring in art and has a minor in history. Amy.
Thank you, Dr. Bob. Our speaker today, Ed Whelan, is president of the Ethics and Public Policy Center. A lawyer and former law clerk to Supreme Court Justice Antonin Scalia, Whelan has served as Principal Deputy Assistant Attorney General for the Office of Legal Counsel in the Department of Justice and is General Counsel to the U.S. Senate Committee on the Judiciary. He graduated Phi Beta Kappa and with honors from Harvard College and received his JD Magna Cum Laude from Harvard Law School, where he was a member of the Board of Editors for the Harvard Law Review. He is a frequent contributor to NRO's Bench Memos blog. And our topic for today is a supreme standard, constitutionalism and the Supreme Court selection process. Please join me in welcoming Ed Whelan.
Thanks, Amy. Thank you, David. Thanks to all of you for being here. Thanks especially to the Kirby Center for conducting this excellent series. Here we are in the midst of another Supreme Court nomination. This is the fourth vacancy in the past 5 years. All this is occurring after an unusual 11-year hiatus in which we had no vacancies. That was the longest such stretch since 1823, back in the days of the court of John Marshall. And of course, we may well have some more vacancies in the coming years before too long passes. Now, as with recent nominations, there's a flurry, a swirl of arguments and counter-arguments about whether Elena Kagan should be confirmed, about how the senators should conduct themselves, about whether she's qualified, why she's not qualified. All this can get rather dizzying. And what I hope to do today is step back and explore first principles in order to help orient the question properly. I'll then discuss the Kagan nomination and Elena Kagan's record and apply these principles to her nomination, and hope to leave plenty of time for your questions as well. Let's begin with the question, what should a president look for in a Supreme Court justice? President Obama has given his own answer to that question. That's maybe a useful place to start. He's given his answer in his notorious empathy standard. Now, have in mind that President Obama's empathy standard was not some offhand remark that he made. He articulated it first in his carefully prepared floor statement explaining why he was voting against the confirmation of John Roberts to be Chief Justice. And what he said in that statement is really remarkable. He said that, look, there are plenty of cases where everyone will agree, but there are other difficult cases that can only be determined, this is a quote, on the basis of one's deepest values, one's core concerns, one's broader perspectives on how the world works, and the depth and breadth of one's empathy. And pounding the point home, he said, in those difficult cases, the critical ingredient is supplied by what is in the judge's heart, not in the judge's mind as applied to legal materials, certainly not in legal materials out there, but in the judge's heart. In running for president, he again embraced this standard. Very similar language in a speech to the Planned Parenthood Action Fund, for example. He said, we need somebody who's got the heart, the empathy, to recognize what it's like to be a young teenage mom, the empathy to understand what it's like to be poor or African American or gay or disabled or old. And that's the criterion by which I'll be selecting my judges. All right? Well, not all right is the clear answer that the American people have given, and President Obama has been running from his own empathy standard ever since. Let's be clear, there's nothing wrong with empathy. Empathy properly understood is, of course, a good thing, and most of the battles in the political arena involve sorting out just what empathy is and how it ought to be implemented in public policy. But the traditional virtue of judging is dispassion, not indulging empathy. And what we see in President Obama's empathy standard is a really radical notion of what a Supreme Court justice should be. Someone who is indulging his or her own values in defining what the Constitution means, inventing new rights. When Obama talks about difficult cases, it's clear he's talking about cases in which application of traditional legal materials doesn't yield the results that he wants, in cases that really matter to him. Well, let's go back then to the question, what should a president look for in a justice? And the answer to that, as we see with Obama, is going to turn on a president's understanding of what the court's proper role is. And of course, the right answer turns on a proper understanding of what the court's role is. And questions that we need to think about here is law distinct from politics? If it's not, if as the left often tells us, law is just politics, then why not just pick a politician or Oprah? I mean, who better manifests the qualities that President Obama was talking about than Oprah? Is there such a thing as a judicial craft? And if so, what does it consist of? How does a person develop the skills that make up the judicial craft, and how does a person manifest those skills so the president can identify, aha, here's someone who's competent, well qualified to be on the Supreme Court? I think that there are several possible answers to that, I would submit. I mean, judicial experience, I think, is first and foremost the best way to both develop the judicial craft and to manifest it, and it's neither a surprise nor anything to be embarrassed about that all 9 of the current justices had previous judicial experience before joining the court. Now, we can look at their records, and I'm not sure that I would say in each case that their experience would be fully qualified. But there's no doubt that as craftsmen, they have, craftswomen, they have a certain level of ability. High-level litigation is obviously another way in which one can develop some of the skills that are important. Grappling with difficult questions of federal law in positions in the federal government, in the Office of Legal Counsel, for example, is another excellent way. And again, it's no surprise that former Chief Justice Rehnquist, Justice Scalia, and Justice Alito all had experience in the Office of Legal Counsel. And serious academic writing, of which there's so little, but obviously is another vehicle by which one can show and develop the ability to grapple with these difficult questions. But when we're asking about what the court's proper role is, another question beyond some sort of objective measure of can someone structure arguments is, are there right and wrong, better and worse methods of constitutional interpretation? And that's a question to which I'd like to devote a good chunk of time here. Now, the text of the Constitution admittedly provides little guidance on that question or on these other questions I referred to related to what a president should look for in a justice. We know that the text says that the president shall nominate and by and with the advice and consent of the Senate shall appoint judges of the Supreme Court. We know also that the judicial power of the United States shall be vested in one Supreme Court, and the judges shall hold their offices during good behavior. Now, we see, of course, that the Constitution is distinguishing judicial power from executive power and legislative power, but these mere words don't tell us much about how that power is to be exercised. What we need to do is turn to the underlying principles that animate those provisions, and I think a good place to start is with Federalist 78, Alexander Hamilton, the very document in which Hamilton was justifying the exercise of judicial review, the term we lawyers use to talk about as judicial review, the power of the court to strike down democratic enactments that violate the Constitution. Here's what Hamilton had to say in that Federalist 78. It can be of no weight to say that the courts, on the pretense of a repugnancy, may substitute their own pleasure to the constitutional intentions of the legislature. In other words, it's frivolous to say that the courts can just pretend that something violates the Constitution. The courts must declare the sense of the law, and if they should be disposed to exercise will instead of judgment, the consequence would equally be the substitution of their pleasure to that of the legislative body. And then his kicker conclusion, the observation, if it proved anything, would prove that there ought to be no judges distinct from that body. In other words, if judges are simply exercising their empathy, indulging their own sense of what's right and wrong, they have no warrant to strike down legislation, and they're basically defeating the authority for the very justification for the role that they have. As Hamilton explains, the power of judicial review is ultimately rooted in the power of the people as declared in the Constitution. Now, Hamilton's proposition that the courts must declare the sense of the law leads naturally to the question of how the courts should determine that sense. That is to the broader question of judicial philosophy, or as Hamilton put it, discerning the nature and reason of how courts should carry out their role. Which leads me to the topic of originalism, specifically original meaning jurisprudence. Now, the term originalism sounds obscure and dangerously exotic to the modern ear. As Justice Scalia has put it, people ask him, when did you first become an originalist? In much the same tone and manner they might use in asking when he first began eating human flesh. In fact, there's good reason that the term originalism is arcane. The term itself appears to be of recent vintage, from the 1980s. Now, that's not because there's anything novel about the substance of originalism, precisely the opposite. Until recent decades, originalism had been so unchallenged, in theory at least, as constitutional orthodoxy, that there was no reason to develop a term that would distinguish it from any rival. As Justice Scalia has put it, in the past, non-originalist opinions have almost always had the decency to lie, or at least to dissemble about what they were doing. But the express abandonment of originalism in recent decades made necessary a label for what everyone had previously recognized as elementary. Now, if this sounds counterintuitive, let me offer an analogous semantic development that I think illustrates the phenomenon. According to the Oxford English Dictionary, the term heterosexual came into usage barely a century ago. Now, that's obviously not because heterosexuals did not exist before then. Rather, it's precisely because what we now call heterosexuality had been widely understood to be normative. So what is originalism? Well, succinctly stated, the term identifies the principle that the meaning of various provisions of the Constitution and of other laws, including a statute enacted yesterday, the meaning is to be determined in accordance with the sense they bore at the time they were promulgated. And I think that the common sense, intuitive appeal of originalism may be shown through an example. Let's take a provision of the Constitution that, at least until the controversy over John McCain's birth in the Panama Canal Zone, seemed well removed from the distorting effects of political bias. That's the clause of the Constitution that sets forth the criteria to be eligible to become president. Specifically, I want to refer to the first criterion, that one must be a natural-born citizen. Now that's an obscure phrase, natural-born citizen. As the protagonist in Ring Lardner's baseball story says when he runs across it on a draft registration form, I wonder what they think I am. Maybe they think I fell out of a tree or something. Now how should we go about figuring out what the phrase natural-born citizen means? One approach, which might fairly be called current meaning textualism, would attempt to determine the current meaning of the phrase. And adhering to this approach might note that we talk these days about natural childbirth, and there's a seeming linguistic connection between natural born and natural childbirth. So maybe it follows if your mother used epidurals or other painkillers during her birth, you were not natural born and are not eligible to become president. Now, a second approach might draw on the inspirations of literature for inspiration, on the insights of literature for inspiration. And here, Shakespeare's Macbeth would seem to offer particular help. Macbeth finds great comfort in the promise that none of woman born shall harm him, but his comfort proves unwarranted when Macduff, who was from his mother's womb untimely ripped, kills Macbeth. So under the inspiration of this literary approach, it would follow that anyone whose birth was by a sort of cesarean section is not a natural-born citizen. Now, under a third internationalist approach, a judge might determine that the natural-born citizen requirement, whatever it means, is obviously a relic of a benighted and xenophobic past, a past that evolving standards of decency, as reflected in modern transnational European electoral practices, requires be abandoned. It simply isn't fair, this judge would conclude, that any candidate should be excluded by such an arbitrary requirement from running for president. The judge might instead invoke the right to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life, as he instead substitutes his own arbitrary criteria for eligibility. That mystery passage, as I'm sure most of you recognize, is the passage that the Supreme Court, the authors of the joint opinion in Planned Parenthood v. Casey, relied on in justifying their continued power grab on the abortion issue, the right to define one's own concept of the existence, of meaning, of the universe, and of the mystery of human life. Now, a fourth approach, that of originalism, would aim to determine the meaning or intent or understanding of the natural-born citizen requirement at the time that phrase was incorporated into the Constitution. A radically counterintuitive notion, right? Well, if, as I hope and suspect, it's obvious to you that this fourth approach is a sound one, then I submit that you are an originalist. And it's striking that in all the public discussion over whether John McCain's birth in the Panama Canal Zone meant that he isn't a natural-born citizen, virtually all commentators purported to undertake an originalist inquiry. Whether or not they did it well is a separate question, but they all tried to look back and understand what that term meant at the time it was adopted. And the same intuition, the same common sense that you and others apply to this somewhat opaque but relatively non-controversial provision of the Constitution should apply to all the other provisions. Now, I strongly suspect that many heterosexual English speakers 2 or 3 generations ago disliked the odd term heterosexual and were not particularly eager to have that label applied to themselves. But I encourage you to take delight in the term originalist, knowing that it's soundly based, and you ought to have the same reaction that Moliere's character did when he discovered that he had been speaking in prose all his life without even trying. He was really, really delighted about that. Okay, well, let me turn then to the original meaning species of originalism. Again, my first part of my argument here is that originalism is at the core of any sound constitutional philosophy that any president committed to the Constitution ought to be looking for. Now, there are competing schools of originalism, and even within any particular school, there are important subsidiary methodological issues I'm not going to get into, but that people have different views on that can be sorted out. But I think it's fair to say that the original meaning approach that Justice Scalia has advocated is now dominant among originalists. And I'd just like to explain what that approach is. Here's how Justice Scalia set it forth in the District of Columbia v. Heller case, the Second Amendment ruling from 2 years ago. In interpreting the Second Amendment, he said, we are guided by the principle that the Constitution was written to be understood by the voters. Its words and phrase were used in their normal and ordinary as distinguished from technical meaning. And this general tenet that he cites is deeply rooted in the American understanding. Thomas Jefferson, as president, wrote, "The Constitution on which our Union rests shall be administered by me according to the safe and honest meaning contemplated by the plain understanding of the people of the United States at the time of its adoption." Joseph Story, the great justice and constitutional scholar from the early 19th century, likewise observed, "Constitutions are not designed for metaphysical or logical subtleties. They are instruments of a practical nature, founded on the common business of human life, adapted to common wants, designed for common use, and fitted for common understandings. That people make them, that people adopt them, that people must be supposed to read them with the help of common sense." And Justice Scalia's opinion in D.C. Heller, I think, is an excellent example of the resources one looks to in determining original public meaning. Justice Scalia looked to 18th century dictionaries, contemporaneously adopted provisions of the Constitution, other founding era sources, state constitutional provisions, ratification debates, all things like that. Now, I also want to highlight that there's, I think, a very interesting piece written in recent years by law professor Lawrence Solom that shows that original meaning originalism is, as he puts it, grounded both in common sense and widely accepted theoretical ideas about meaning and the nature of law. He grounds original meaning originalism in the philosophy of language and linguistics and how we communicate over time. I won't get into his more elaborate argument here, but I think what he says is the common sense of originalism is deeply rooted in how we understand language. Now, there have been a handful of, well, lots of attacks on originalism, and I'm going to identify some of them in order to clarify what the original meaning methodology is. One claim is that the original meaning methodology leads to conservative results. Well, properly applied, the methodology leads to constitutionally correct results, but I want to emphasize that the claim that leads to conservative results really obscures quite a bit. Folks claim, for example, one author in the New Yorker said it leads to conservative results, at least on social issues like abortion, capital punishment, and gay rights. That's exactly wrong. On all three of those issues, what originalism leads to is the conclusion that those matters, abortion, capital punishment, and gay rights, are matters that the Constitution doesn't address, are matters that are to be worked out through the political processes to reach whatever result that the people work out. In other words, that the Constitution is substantively neutral on those matters. It's not the case that you have originalists arguing that the Constitution prohibits the democratic enactment of same-sex marriage, for example, or that the Constitution requires that the death penalty be administered in a certain class of cases, or that the Constitution forbids permissive abortion laws. On all those matters, and on the originalists occupy the middle ground, saying the Constitution is substantively neutral, and it's the left that has entrenched its views in the Constitution, and there's not a counter-effort to entrench conservative views in the Constitution. There's also the claim, equally meritless, that originalism lacks the flexibility needed to adapt to changing circumstances. This is the claim made by typically by proponents of the so-called living Constitution, that is the make it up as you go along approach. And what's really striking about it is how it ignores, well, basically, under originalism, the Constitution gives broad play to democratic processes to, for example, enact permissive abortion laws, then to say, wait a second, that's been a real mistake, we ought to have some prohibitions, to adapt over time to changing circumstances. It's the living Constitution and its modern insistence on entrenching the left's agenda in the guise of constitutional rights and then claiming that stare decisis adherence to precedent is sacrosanct, that prevents the flexibility over time. It prevents the democratic processes from saying, oops, we made a mistake, let's revisit this. And a third objection to originalism is that it doesn't provide answers to all questions. Well, this objection is substantively correct. Originalism doesn't provide answers to all questions. But it's recasting a fatal vice of non-originalist methods as though it's a virtue. Of course, if you're a living constitutionalist and the Constitution means whatever you want it to mean, you'll have an answer to every question. What do I want? You know, what do I think is, you know, in which direction is history taking us? I mean, you can have your answer. Different folks may, different living constitutionalists may have different views, but it is the case that that originalism will sometimes not have clear answers to certain questions that are presented. That's why originalism needs to be supplemented by principles of judicial restraint, as I'll discuss next. But it's not a flaw in originalism itself. But what do I mean by judicial restraint? There's a supplemental principle that I think needs to accompany originalism. Well, the core principle is that judges simply have no authority to override a democratic enactment if their interpretive methodology fails to make it sufficiently clear that an enactment is unconstitutional. If you really can't tell, you look hard and you can't tell whether a statute violates the Constitution, the judge's obligation is to get the heck out of the way. I will emphasize judicial restraint is sometimes confused with simply adhering to precedent. And look, stare decisis or adherence to precedent has an important role to play in the way judges carry out their obligations day to day. I compare it to, you know, when you go out to your garage every day, you don't have to disassemble your car and then reassemble it. You can assume usually assume that it's in working order. But, you know, if you've been going out to your car in the morning and it's smoking like crazy and you try to start, it doesn't go anywhere, you know, maybe it's time to reconsider things. And I think the best example of a case that desperately needs revisiting is Roe versus Wade, a case that has, for 37 years now, corrupted our national politics, removed this contentious issue from the democratic processes where it belongs, and, you know, has really warped the way public life is carried out. So let me sum up then on the president's role. I think the president has an obligation to form a sound judicial philosophy and to have that judicial philosophy be an important part of his selection of a Supreme Court justice. Now, how should the Senate carry out its advice and consent role? Well, again, the Constitution provides little or no guidance on this, and I think senators, in theory, could vote on virtually any basis. It's worth noting that the modern process that we take for granted, Senate Judiciary Committee hearing, is relatively novel. The first questioning by senators took place in 1925 and then didn't occur again until 1939. But there are, I think it's fair to say, two basic competing models on the substance of the Senate's role. One model is one of deference to the president. Some versions complete deference, others very extensive. You often hear the claim that if someone is objectively qualified, the only question is whether they are outside the mainstream. Of course, both these terms, objectively qualified and outside the mainstream, smuggling in notions that are, I think, highly contestable. The second model would involve a strong focus on judicial philosophy and insistence that someone who occupies that important role of Supreme Court justice have a judicial philosophy that indicates that person will be faithful to the Constitution. Interestingly enough, Elena Kagan herself embraced the view that judicial philosophy ought to be central to the Senate's consideration of a Supreme Court nominee. This was back in a 1995 long article, book review that many in the White House are trying to run away from. She had this to say: when the Senate ceases to engage nominees in meaningful discussion of legal issues, the confirmation process takes on an air of vacuity and farce, and the Senate becomes incapable of either properly evaluating nominees or appropriately educating the public. Further, the kind of inquiry that will contribute most to understanding and evaluating a nomination is discussion first of the nominee's broad judicial philosophy, and second of her views on particular constitutional questions. Kagan complains that responses to questions on judicial philosophy generally have become platitudinous That's why she insists on the second aspect of the inquiry, the insistence on seeing how theory works in practice by evoking a nominee's comments on particular issues involving privacy rights, free speech, race and gender discrimination, and so forth, that the court regularly faces. Now, I submit that there's really nothing favorable that can be said in theory about the deference model. Again, if you agree, as I do, that as I'm maintaining that judicial philosophy ought to be central to the president's selection role, how is it that the Senate shouldn't be considering this as well? Now, there are possible practical defenses of the deference model. Indeed, if we lived in a legal culture in which there were no meaningful disputes about judicial philosophy, then we could well trust that the president was making was picking someone who had a sound understanding. You could just look to secondary factors. Likewise, if we knew we had a president who had a sound understanding of judicial philosophy and picking his nominees, deference might well be appropriate. It's quite possible that some senators might think that the Senate is institutionally incompetent to explore judicial philosophy. Unfortunately, there's some empirical data to support that, but I don't think that theory explains the Senate's course of conduct, nor I think does it excuse senators from making sure that they develop the competence to address these questions. Perhaps the most serious practical argument for the deference model is the claim that it's needed to protect judicial independence. Often this claim never goes beyond a slogan, and I'd say, beware general claims of judicial independence. And Elena Kagan herself, in her piece, complained that the term judicial independence was often used in a fuzzy and inflated way, and that life tenure and the other protections that the Constitution gives to judges were adequate assurance of judicial independence. But a serious commentator, Stuart Taylor, recently wrote that in defense of the deference model, that this model is needed to avoid forcing nominees to make the moral equivalent of campaign promises that would compromise both their own integrity and the independence of the judiciary. Serious, a serious objection, I think it falters in the end for a couple of reasons. One, you have these Supreme Court nominees having these closed-door meetings with senators all the time. And then oftentimes the senators will come out and say, well, I've just got an assurance on this issue that matters to me. Well, how can we, how can someone tolerate that and then object to a transparent discussion? I mean, I'd much rather have any deals occur in public rather than behind closed doors. Beyond that, I think nominees are perfectly capable of making clear, look, here's my current view based on, here's what I meant when I wrote this 3 years ago. But obviously, I'm open to reconsider things, and I think you can have an open discussion along that line. And again, Elena Kagan back in 1995, I believe very much the same thing. Now, it's striking that there's been a real asymmetry, long been asymmetry between the way Republicans and Democrats approach Supreme Court confirmations. Since the Bork battle, or arguably even the year earlier with the Rehnquist elevation to Chief Justice in 1986, Democrats have tried to make judicial philosophy at the centerpiece of their objection to nominees. Done it time after time after time. Now, so I give them credit for being right on the big question of is judicial philosophy relevant. They're wrong in having a completely wrong understanding of judicial philosophy, and secondarily in using attacks, invented attacks on racism, sexism, and all these other things to try ethical attacks to try to show that someone is unqualified. But it's striking that all the way back, again, for more than 20 years, Democrats have made judicial philosophy the heart of their battle against nominees. Republicans didn't do that. I mean, I worked for Senator Hatch in 1993 and 94 when Justices Ginsburg and Breyer were confirmed. Justice Ginsburg was confirmed 96-3. Justice Breyer, 87-9. The confirmation hearings were virtual love fests, with even Strom Thurmond saying, "Oh," to Justice Ginsburg, "Oh, if you don't have to answer that question if you don't want to." And I think it's interesting to ponder why Republicans persisted in this position of deference to picks of an opposite party president, even after it seemed clear that the Democrats weren't going to be taking that same approach. Now, one possible explanation is that Republicans had made the strategic bet that the deference model would yield better justices. That is, in particular, they had thought, oh, well, the Senate is usually going to be dominated by Democrats. Republicans have a better chance of getting control of the presidency. So if we're able to establish this deference model, picks of Republican presidents will be deferred to by Democrats. It'd be a sensible enough theory to pursue. I think it had been proved wrong by 93 and 94. And I would suggest that, unfortunately, instead, what may have affected a lot of Republican senators was that it was a lot easier, a lot more in their self-interest to simply lie down and play dead on Supreme Court nominations. And I think if we use a model of, if we looked at public choice theory and look at a model of a senator's incentives, you can see that if you don't have a mobilized base driving you in one direction, a senator could say, look, the easiest path to re-election involves no controversy, and voting against someone is a sure way to generate controversy. And if I can find a reason to vote for this person of the opposite party, I can placate my base by invoking this principle of deference to the president. I can present myself as a reasonable centrist to anyone on the other side who would want to run against me or vote for my opponent. And I think I offer that as at least a partial theory for Republican persistence in the deference model. Well, I'm pleased to say that I think the Sotomayor confirmation process last year shows that Republicans put judicial philosophy front and center. Obviously, they were in a definite minority, but I think the process, more than that of any other in a long time, I think is really a model of how concerns about judicial philosophy ought to dominate the process. That the hearing was done in a respectful way. We can all, which certain questions were asked, in better ways. I'm not saying it was ideal, but I do think that Republicans weren't hiding behind the principle of deference to the president. Most of them weren't, and were instead engaging in a serious exploration of how a Justice Sotomayor would act on the court. And of course, you had Justice Sotomayor trying to camouflage herself as some sort of judicial conservative in a way that's utterly implausible, and you ended up with 31 negative votes against her. So I think it's, in many ways, I think it represents a repudiation of the deference model. I'll talk very briefly on the nominee's own role in the process. I think Elena Kagan said it best in a 1995 law review piece. Speaking of Ginsburg and Breyer, she said, "I suspect that both appreciate that for them, as for most, the safest and surest route to the prize that is of confirmation, lay in alternating platitudinous statement and judicial silence. Who would have done anything different in the absence of pressure from members of Congress?" So the challenge, the obligation of senators is to engage in a thorough review of the nominee's record, including an examination of judicial philosophy, and we hope we'll see more of that in the coming hearing. Let me talk a bit about Elena Kagan's record, and hope to leave some time for questions. I think it's clear that Obama's empathy standard is part and parcel of his effort to remake America in his image. As he pursues projects such as this sweeping healthcare reform or ruination, however you see it, it's clear that he wants justices who will ignore constitutional limits that stand in his way. At the same time, he wants justices who invent new constitutional rights on matters such as same-sex marriage that permanently impose the agenda of the left. Now, Elena Kagan has, in many respects, a very scanty record. Very limited experience is actually relevant to the role of the Supreme Court. Zero judicial experience. I'm not saying judicial experience is a necessity. I am saying it's the best training, and that its lack is a deficiency that needs to be compensated for by something else. She has only a few years of real-world legal experience. She had never argued an appeal anywhere before becoming Solicitor General last year. During her entire career in academia, she's generated only a handful of scholarly articles, which one liberal law professor critic summarized as cautious academic exercises in a sort of banal, on the other handing, as on the one hand, on the other hand, whose prime virtue is it's unlikely to offend anyone in a position of power. Kagan has been remarkably guarded about expressing her political and legal views over the last couple decades. One person who knows her well has said he doesn't know anyone who's had a conversation with her in which she expressed a personal conviction on a question of constitutional law in the past decade. But don't conclude from this that she's anything other than a creature of the left. The pattern is there when we see her views. They're quite clear. All the way back to election night in 1980 when she wrote in her student newspaper at Princeton of her despair at the takeover of the Senate by Republican avengers of innocent life. And she wondered, what could possibly have happened had the world gone mad. She wrote her senior thesis at Princeton on the history of socialism in New York City. And no, I'm not arguing that writing a thesis on the history of socialism in New York City means that someone is a socialist. I will point out, though, that she found it puzzling as something that cries out for explanation that Americans are more likely to speak of capitalism's glories than of socialism's greatness. Isn't it puzzling that Americans aren't talking about socialism's greatness? And she lamented the story of the strange death of socialism in New York City as what she called a sad but also a chastening one for those who, more than half a century after socialism's decline, still wish to change America. Well, I think it's quite clear that she viewed that as she herself viewed it as sad. She wrote a couple years later a graduate thesis at Oxford in which she said it was fine for judges to mold and steer the law, this is her quote, in order to promote certain ethical values and to achieve certain social ends that they favor, so long as they cover up their decisions by what she calls, so long as their decisions could plausibly be grounded in principles referable to an acceptable source of law. What she's clearly interested in there is making sure that you could basically fool the yahoos out there by dressing up these rulings in legal argument, not actually apply sound interpretive methods to get to the right result, but you figure out your own vision and then see how you can manipulate legal materials to seem to justify where you want to get. The White House is right to declare that she's clearly a legal progressive. She's lauded Justice Thurgood Marshall's jurisprudence. She was a law clerk for him. She said that Marshall's view was the court had freewheeling authority, quote, to safeguard the interests of people who had no other champion. Indeed, she said that the court existed primarily to fulfill this mission. And she complained that some justices have sniped at Marshall's vision and called it a thing of glory. She lauded Judge Bork's borking as a model of a serious discussion of the meaning of the Constitution as a model of how a confirmation hearing ought to proceed. She's very lucky that her critics have a much higher standards than Bork's, and that her process will not be like that. She's criticized the ultimate wrongheadedness of Justice Scalia's approach. She's called Ruth Bader Ginsburg a well-known moderate. And there's this Israeli justice, Aaron Barak. Judge Richard Posner has said, without a secure constitutional basis, created a degree of judicial power undreamt of by our most aggressive Supreme Court justices, and who has rulings on important issues like standing who can pursue a legal claim in court that by American standards are just crazy. Well, Elena Kagan has proclaimed him, quote, my judicial hero, and again has lavished him with praise. Let me highlight one issue that's gotten some attention so far and try to put it in proper context. This is Elena Kagan's course of conduct on the Solomon Amendment. This is the one issue on which she has engaged in vehement rhetoric, and she condemned Don't Ask, Don't Tell as a profound wrong, a moral injustice of the first order. I would have thought that genocide and things of that nature would be moral injustices of the first order, and that Don't Ask, Don't Tell would be something on which reasonable people have different views. But when she became dean in 2003, she followed the course of action that her predecessor had established the year before under pressure from the military, of giving military recruiters access to the law school jobs office while sending letters to the law school community condemning them. 1 year later, though, after a federal court ruled that the Solomon Amendment was unconstitutional, she saw an opening to be more aggressive. I should make clear the Solomon Amendment was a measure that Congress adopted to basically help implement Don't Ask, Don't Tell. It said to universities, if you don't give military recruiters equal access on your campuses, you're going to be disqualified from receiving federal funds. Well, even though this federal court ruling never became legally effective, even though the Supreme Court granted review, Kagan used this as an excuse to kick military recruiters off campus. And her defenders try to say, oh, well, the recruiters, she kicked them out of the jobs office. Her defenders say, oh, well, the recruiters could still use the Student Veterans Association to organize their interviews. It's quite clear, as the Veterans Association has said, that they did not have the resources to come anywhere close to replicating the services of the jobs office. And Kagan also then signed her name to an amicus brief in the Supreme Court case where her position was unanimously rejected by the Supreme Court. So in sum, what we have here is an exercise of cheap moral posturing. Kagan elevated her ideological commitment on gay rights above what Congress, acting on the advice of military leaders, had determined best served the interests of national security. She directed her verbal fire entirely at the military, not at the politicians, who in fact bore ultimate responsibility for Don't Ask, Don't Tell, not at her former boss, President Clinton, who had signed into law the measure that gave rise to Don't Ask, Don't Tell. In the midst of war, she violated the Solomon Amendment by treating military recruiters worse than she treated the elite law firms that were donating their services to anti-American terrorists and suspected terrorists. And as Peter Beinart, the liberal form editor of the New Republic, has put it, barring military recruiters from the jobs office amounted to, quote, a statement of national estrangement, close quote, of Kagan's, quote, alienating herself from the country. It's also, I want to emphasize, worth noting that Kagan appears to have indulged her ideological bias on gay rights as Solicitor General by undermining the federal laws that she was duty-bound to defend. Now, we often hear, and I think the point is often well taken, that when Kagan, as Solicitor General, defends a federal law, well, that's her job. You can't impute to her agreement with that federal law. Well, here, it was her obligation to offer a vigorous defense of the Defense of Marriage Act in one of these cases, and Don't Ask, Don't Tell in another, and she didn't do it. She failed to seek Supreme Court review of a rogue Ninth Circuit ruling that threatened Don't Ask, Don't Tell, and it subjected the military to burdensome litigation. And under her charge, the Department of Justice filed a brief that gratuitously abandons strong grounds for defending the Defense of Marriage Act. One proponent of same-sex marriage celebrated the brief as a gift to the gay marriage movement that will no doubt make its way into judicial opinions. Okay, so let me be brief here as we're running short on time. I want to make sure you have time for questions. But how should the Senate act? Well, I think it's quite clear that there's nothing in Elena Kagan's record to indicate that she has a sound judicial philosophy. I think her, even on objective experience, her record is marginal, precisely because so little is known about her legal and policy views, and because what little is known suggests that she may indulge her sense of empathy in making legal judgments. It's especially important that the Senate conduct a thorough examination of her views, and the burden should be on her to establish that she's not that she is qualified. There should be no deference, especially here where we have a president who's acting under a patently irresponsible standard, and a nominee whose record gives no signs that she understands what it means to be a Supreme Court justice. Thank you. Looks like we have a roving microphone, so I think if you raise your hand and the mic will come to you.
Thank you for an excellent and extremely enlightening speech. Question about hearings. There was a time, I think, when the Senate didn't hold hearings with nominees. And now, of course, they're de rigueur. What has changed? And what purpose do you think hearings serve?
Well, again, you're right. There were no hearings before the 20s, and it's irregular even after that. What purpose do hearings serve? I guess that question can be answered in perhaps two different ways. What purpose should they serve, and what do they actually do? I think, unfortunately, in terms of what do they actually do, hearings are television time for senators, and it can be a time simply to politic. And I think this is a comment that has bipartisan application. You know, it could be, okay, here's my time. I want to get my 15 seconds on my local news asking the question that I think is going to be of particular concern to my constituents, or I want to berate this nominee so people will understand why it is that I'm voting against the nominee. The hearing, of course, is in many ways there's the culmination, seeming culmination of the confirmation process, the opportunity for the nominee to speak out and actually address some of the charges, in some cases, obviously, the past false charges that have been raised about nominees, and I think it serves an important role there. I think John Roberts and Sam Alito both were able to use the hearing well to show that they were not what they had been falsely portrayed to be. I think Sonia Sotomayor did exactly the opposite last year, disguising her views. Her answers on the role of foreign law in construing the Constitution should have been a national scandal, and you know, I think it gave ample reason for anyone to vote against her. But what should the hearing be? The hearing ought to be a serious exploration of judicial philosophy. It ought to be at a time when senators engage and ask questions and listen to the answers, and do intelligent follow-up, and show that they have an understanding of the proper role of the courts in a system of representative government, and show that they're serious about making sure that the justices do. The hearing's it's a tough environment. The rounds can be so short, and unfortunately there's so many senators, again, I think this is a bipartisan comment, who are so used to hearing themselves talk that they think that it's perfectly proper to fill up their 15 minutes with 12 minutes of speechifying that they could do at any other time. Where what they ought to have is a series of crisp questions that that they've thought about beforehand and actually run through. I mean, the nominees go through these moot courts or murder boards. How many senators do you think ever do? I guess the number is very low. So there's lots of room to improve the way that the hearings are conducted. But I do think the hearing has an important role, and the challenge here is to make better use of the opportunity. In the back?
Yes. In the discussion of originalism, the left often brings up Plessy versus Ferguson.
I wonder if you'd comment on the interaction of originalism and that decision case, and obviously Brown versus Board of Education as well.
Sure. Well, the left's standard, or their supposed big stick to beat originalism is that their claim is that the result in Brown versus Board can't be justified on originalist grounds, and they seem so interested in establishing that, more interested in establishing that than even understanding originalism. Look, there have been some very serious originalist justifications for Brown that have been offered. Michael McConnell, has offered one, you can examine those and see whether you find them convincing or not. If you don't find them convincing, I'd submit that the logical conclusion is that the problem is the 14th Amendment. That is, if you think the 14th Amendment properly construed according to originalist principles doesn't prohibit state-enforced segregation, then your complaint ought to be about the 14th Amendment. Plessy, of course, was the decision in the 1890s, 1896, I believe, that upheld segregation, state-mandated segregation in streetcars or trains, I forget exactly which. And in many ways, what you see in Brown was this excessive deference to precedent. Because what the court, it's often said, oh, Brown overruled Plessy. We look at Brown. Brown doesn't say we overruled Plessy. Brown says the question in this case is whether the rule of Plessy extends to public education. And we rule that it doesn't. And it is so, it's committing the same flaw of not re-examining its own precedent and taking its own precedent as sacrosanct. And of course, the first Justice Harlan had a wonderful dissent in Plessy that relied on his understanding of the original public meaning of the post-Civil War amendments to reach a very different conclusion. So, I think that the resort to Brown to argue against originalism is flawed on multiple grounds.
Recently there have been a number of cases where religious freedom, First Amendment right to religious freedom conflicts with these anti-discrimination laws. And notably a case where a counselor in a counseling program in a college refused to counsel a gay couple on marriage, and she was thrown out of the program and she sued to get reinstated to the program, saying her religious rights were violated. In these kinds of cases, according to what the distinction you made between empathy and originalism, how would the justices decide that one right overcame another? Well, why wouldn't religious freedom be just as important in that case as anti-discrimination?
Well, let me try to address that in the abstract. I would say it's not the proper role of the justices to try to mediate competing values in the Constitution. The question is whether an enactment violates a command of the Constitution. If it does, it should be invalidated. If it doesn't, even if the enactment is something that we find offensive, the justice finds offensive, the justice needs to let it stand. And the obligation then is for us to work through the political processes to fix those laws. Now, I don't mean to take any position or offer any view on any of the cases you're referring to. I think what you have, I think what's happened in a lot of cases is you have these public accommodations laws that have been construed very, very expansively by the courts in a way that no one ever imagined, and that's a lot of what's created the clash. There may be different ways to fix that. Maybe, as your question is asking, maybe there's a violation of constitutional command. If not, the political processes in the particular political jurisdiction need to be employed to fix the problem. Yeah.
My name is Charlie Kuhn, and I used to work at the Heritage Foundation years ago, and I've worked on the Hill, and it's been many, many years since I took my constitutional law class, so you'll have to excuse me.
You're
But
probably better off for having been many years ago.
probably so. It was always very liberal. But anyway, I've become a real advocate, if you will, of Mark Levin, and I'm reading Men in Black for about the third time. And as I recall, he makes a comment that judicial review was an abridgment of the Constitution and the separation of powers. I mean, I'm not really sure if I understand what he means by then judicial review. What is the Supreme Court supposed to do, and what are they doing that they're not supposed to do?
Well, I'm not familiar with Mark Levin's argument on this, so I'm not going to be responding to that. I will say that I think that it's fairly well established, as the Hamilton quote that I cited indicated, that the traditional understanding is that courts would have the power, in cases properly before them, to say whether a particular statute violated the Constitution. And I think that the existence of that power of judicial review is not what ought to be objected to. It's the manner in which it has been so abused, so wrongly exercised. Again, it's been entirely divorced from what Hamilton saw as its essential founding in the sense of the language. So that's, I think, where the focus needs to be.
And this will be our final question.
Hi. It seems like the Senate hearings came about around the same time period as the 17th Amendment. And do you think, I was just wondering if you could offer any insight about the states as states having representation in the judicial selection process, and if, since the erosion of the federal state, is there any large effects because of that?
It's an interesting theory. Obviously, once you had the 17th Amendment and the direct election of senators, the senators had an incentive to respond more directly to the people rather than to the state legislatures, and that would change the way they carried out their jobs. I would think, in recent decades, television probably has more to do with it, but it may well be. I think that the initial hearing, which I think it says 1925 or 26, was for Harlan Fiske Stone, who had been attacked by some as a tool of I think J.P. Morgan. So there's a populist attack on him, and the hearing was an opportunity to explore that and for him to counter that. Yeah, he was said to be the tool of the House of Morgan. I can't really speculate beyond that. I think that there are lots of folks who are able to trace various degradations in our political process to the 17th Amendment, I'm sympathetic to some of those arguments. I haven't examined them closely enough myself, though, to know how well they hold up. Well, thank you all, and appreciate being here.
Thank you very much, Ed. We appreciate your time, and let me remind you once again that our next lecture will be held on July 9th, David Horowitz, and also that one of Ed Whelan's colleagues in Senator Hatch's office, Justice Stephen Markman, who now sits on the Michigan Supreme Court and teaches constitutional law for Hillsdale College, has just published a white paper, the Kirby Center's first. It explores the theme of the coming constitutional debate, a debate that Justice Markman warns if citizens don't join, it will be settled within the ranks of legal academia. You can find that white paper on the Kirby Center's website, thekirbycenter.org. Thank you very much for coming.